in the context of higher education, student body diversity is a compelling state interest that can justify the narrowly tailored use of race in admissions. We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interests that we approve today.
Justice Sandra Day O'Connor announced the Supreme Court's decision on the landmark case, Grutter v. Bollinger, in 2003, protecting affirmative action. In that case, the court ruled that the University of Michigan Law School's use of race in its admissions process did not violate the 14th Amendment's Equal Protection Clause. The court held that an applicant's race may be one factor in admission to a public educational institution, so long as it was one of many factors and part of an effort to increase diversity on campus, rather than a fixed quota of minority students. The justices envisioned a future in which the need to consider race would be unnecessary.
Accordingly, race-conscious admissions policies must be limited in time. Enshrining a permanent justification for racial preferences would offend this fundamental equal protection principle.
Now, 20 years later, many anticipate the current justices may overturn or reduce affirmative action. Since the Civil Rights Movement, race-conscious admission policies have been adopted by many academic institutions. Cornell University Law School defines affirmative action as a set of procedures designed to eliminate unlawful discrimination among applicants, remedy the results of such prior discrimination, and prevent such discrimination in the future. Until the 1970s, Harvard College admitted fewer than 12 black undergraduates each year, according to the Harvard Crimson. In 2022, Harvard's undergraduate class was 10.7% black. University of North Carolina, Chapel Hill accepted 4 black freshmen in 1960 and only 18 in 1963. In 2022, UNC's undergraduate class was 10% black. Today, both Harvard and UNC are at the center of separate cases in which the Supreme Court decides if race should be a factor in the admissions process. Students for Fair Admissions versus President and Fellows of Harvard argue that race-based admission policies discriminate against Asian American and white students, while the Students for Fair Admissions versus University of North Carolina argues that race-based admission policies discriminate against Asian American students only. This is not the first time that Asian American students have been considered in an affirmative action case. In 2016, Justice Alito dissented from the majority opinion in Fisher versus the University of Texas and made sharp criticism of UT's practices.
Classes with no Asian American students outnumber classes with no Hispanic students. Yet the university's plan discriminates against Asian American students. How can such a plan be said to promote classroom diversity?
The common link in all 3 cases is Edward Bloom, a conservative strategist and president of the special interest group Students for Fair Admissions, who has now brought an astounding 8 anti-affirmative action cases before the Supreme Court. SFFA's complaint alleges Harvard intentionally and artificially limits the number of Asian Americans to whom it will offer admission.
Asians should be getting into Harvard more than whites, but they don't because Harvard gives them significantly lower personal ratings. Harvard ranks Asians less likable, confident, and kind, even though the alumni who actually meet them disagree.
Harvard has denied these claims and pointed out that previous lower courts have found no evidence of SFFA's claim. Solicitor General Elizabeth Proliger represented the United States government and argued a blanket ban on race-conscious admissions would cause racial diversity to plummet at many of our nation's leading educational institutions. Having served on a Harvard Board of Overseers, Justice Ketanji Brown Jackson has recused herself from the Harvard case. She will, however, be voting in the UNC case. From 1996 to 2012, 8 states banned affirmative action. Since then, public perception of affirmative action has swung from one extreme to the other. According to Pew Research in 2014, 65% of survey participants said they support affirmative action programs on campus, compared to 2022, when 74% of those who participated in a Pew survey said they don't believe race should be a factor in the admissions process. Yet the question remains, what will become of educational institutions if the court strikes down affirmative action? The Supreme Court is expected to announce its decision by June 2023.